Marriage settlements. Article 74 of the Family Code. The property relationship between husband and wife shall be governed by the following order. 1. By marriage settlements executed before the marriage. 2. By the provisions of this code. And 3. By local customs. Requisites for validity. Article 75 of the Family Code. The future spouses agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. And in the absence of marriage settlement, or when the regime agreed upon is void, the system of absolute community property, as established in this code, shall govern. What are the requirements for marriage settlements and any modification thereof under Article 77 of the Family Code? 1. It must be made in writing. 2. Signed by the parties. 3. Executed before the marriage celebration. And 4. If executed by a person below 21 years, valid only when persons required to give consent to marriage, like the father, mother, or guardian, respectively, are made parties to the agreement under Article 78 of the Family Code. The parties have the freedom to stipulate regarding their property relations and their marriage settlements in which the lex intentionis of the parties governs the contract. When the couple agrees on a property regime and their marriage settlement, the provisions of the code are merely supplementary. When modifications can be made as to the marriage settlement. 1. When modification or for modification to be valid, it must be determined before the celebration of marriage. Article 76. 2. Upon finality of legal separation, the property regime is dissolved and liquidated, subject to forfeiture of the guilty spouse, under Article 63, subsection 2. In case of reconciliation, the consideration the separation of property subsists unless the parties agree to revive their former property regime. Article 66 and 67. 4. For judicial separation of property, the following are sufficient causes. A. The spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. B. The spouse of the petitioner has been judicially declared an absentee. C. The loss of parental authority of the spouse of the petitioner has been decreed by the court. D. The spouse of the petitioner has abandoned or failed to comply with his or her obligation to the family. E. That the spouse granted the power of administration and the marriage settlements has abused that power. And F. That at the time of the petition, the spouses has been separated in fact for at least 1 year and reconciliation is highly improbable. Take note, marriage settlements are considered accessory to the marriage. Therefore, as per Article 81, stipulations and considerations of future marriage and donations will be void if marriage does not take place. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage under Article 103, subsection 3. Donations by reason of marriage or donation per prenuptias. Article 82. Donations by reason of marriage are those which are made before its celebration, in consideration of the same and in favor of one or both of the future spouses. Donations per prenuptias are made in consideration of marriage. There can be a valid donation if the marriage never took place, but the absence of marriage is a ground for the revocation of the donation. The case of Solis versus Barroso, 1928. Donation per prenuptias are without onerous consideration, marriage being merely the occasion or motive for the donation, not its cause. Being liberalities, they remain subject to reduction of inefficiousness upon the donor's death if they should infringe the legitimate of a forced heir, under the case of Mateo versus Lagua, 1969. What are the requisites for donation propter nuptias? 1. Made before the celebration of marriage. 2. Made in consideration of marriage. 3. Made in favor of one or both of the future spouses. And 4. In a public document and not merely privately stipulated. Solis versus Baruso, Supra. Who may donate? 1. Spouses to each other. 2. Parents of one or both spouses. And 3. Third persons to either or both spouses. Donations that are excluded are 1. Ordinary wedding gifts given after the celebration of marriage. 2. Donations in favor of future spouses made before marriage but not in consideration thereof. And 3. Donations made in favor of persons other than the spouses if founded on the intended marriage. What are the differences between donation propter nuptias and ordinary donations? Donation propter nuptias does not require express acceptance. Ordinary donations requires express acceptance. Donation propter nuptias may include future property subject to formalities of the will, while ordinary donations cannot include future property. Donation propter nuptias is, if present, is donated and property regime is not absolute community, limited to 1/5 of the property. Ordinary donations has no limitation to donation of present property provided legitimes are not impaired. And lastly, donation propter nuptias, the grounds for revocation of which is found in Article 86, while ordinary donations, the grounds for donation is found in donation laws under the Civil Code provisions. Donations of property subject to encumbrances are 1. Considered valid. 2. In case of foreclosure, A. If the property value is less than the obligation, the donee shall not be liable for the deficiency. B. If property value is greater than the obligation, the donee shall be entitled to the excess under Article 58. Bali, ang imong gidonate is encumbered. Ang donation is still valid, pero in case of ma-foreclose siya, if ang obligation is greater than the property value, the donee shall not be liable for the deficiency. So, ikaw nga nakadawat, you're not obliged to pay for the excess. But, if mas gamay ang obligation compared with the property value, you are entitled to whatever is excess of the obligation. Grounds for revocation of donation propter nuptias. When marriage is not celebrated, donation contained in marriage settlement is revoked by operation of law, and it does not prescribe. Donation contained in a separate instrument is donor's choice, and it prescribes within 5 years from the supposed date of marriage. For void marriages, if dili to ma-celebrate ang marriage, what if naay donation propter nuptias in a void marriage? So generally, there must be a judicial declaration of nullity of void marriage first before ka moingon nga void ang donation propter nuptias. So, under Article 40, in relation to Article 52 and 53, subsequent marriage before securing a judicial declaration of nullity, if the donee spouse contracted a second marriage in bad faith, knowing it was void, kay minyo pa siya sa una, and wala pa na-nullify ang first marriage, donations in favor of the second marriage are revoked by operation of law. Kay general rule man. But, if both parties acted in good faith, revocation will be by donor's choice. So, dili by operation of law. And it should be within 5 years from the date of finality of the judicial declaration of nullity. That is under Article 40, if naay subsequent marriage. How about in Article 44, where bad faith in securing the declaration of the presumptive death. So, nice subsequent marriage, but such marriage was procured upon the presumption or upon the procurement of the declaration of the presumptive death of the absent spouse. So, what happens? If either or both spouses in the subsequent marriage acted in bad faith, knowing that the person was still alive, donations in favor of the subsequent marriage is revoked by operation of law. And then if good faith pod, revocation will be by donor's choice, not by operation of law. And then it can be revoked within 5 years from the date of the finality of the judicial declaration of nullity. And then another void marriage is for all other void marriages. If it is donor's choice regardless of whether good faith or bad faith ang donee. Okay. Donation prenuptials in case of no consent of parents or guardians. Generally, it does not require final decree of annulment because understood naman siya ang annulled. Right? Kaya wala may ko an essential requisite. Revocation will be by donor's choice and done within 5 years from discovery that consent was not obtained. How about in other cases of annulment? It is revoked by operation of law if the donee is the guilty spouse who acted in bad faith. How about when there is no consent of parents or guardians? I think it's kind of the same. General rule, revocation is by donor's choice and done within 5 years from the finality of the decree of legal separation. Except when the cause is adultery or concubinage, it's revoked by operation of law. Normal, tama lang. What if ang resolutory condition is complied with in case of donation prenuptials? So generally, revocation is by donor's choice and done within 5 years from the finality of the decree of legal separation, except when the other spouse is the donor, the action does not prescribe. So, walay prescription. Acts of ingratitude under Article 6 of 765 of the Civil Code. Generally, revocation is by donor's choice and done within 1 year from the knowledge of the fact of ingratitude, with donor being capable of bringing suit. Void donations by the spouses. Donations before marriage. Generally, future spouses who agree upon a regime other than ACP cannot donate to each other more than 1/5 of their present property. Excess shall be considered void. So, ang general rule is 1/5 of your property ra ang madonate nimo. You cannot donate more than 1/5 of your property. The reason for excluding ECP is all property will again be shared by both spouses after the marriage. You share everything in ECP. What is yours is ours. Walay iya. Except the limit of 1/5 applies only when the donation is contained in a marriage settlement. Only in marriage settlements nga di ka makadonate og more than 1/5. If it is contained in another instrument, the general rules on inefficacious donations shall apply. So the rules on donation will apply, not the rule on marriage settlements, not exceeding 1/5 of your personal property or future properties or whatever property. Donations during marriage. Generally, spouses cannot donate to each other, directly or indirectly. Donations made by each spouses to each other during the marriage are void. Under Article 87, these donations refer to donations inter vivos, except when moderate gifts on the occasion of the family rejoicing. The spouse cannot donate to persons which the other person may inherit from, as it constitutes an indirect donation. Okay, Nasarano versus Birog, 1947. Donations between common law spouses. Common law, wala marriage. The donation between common law spouses falls within the provisions prohibiting donations between spouses during marriage. The case of Matabuena versus Cervantes, 1971. In order to fall under the prohibition, it must be provided that they were living in a common law relationship at the time of the donation. Sumbad versus CA, 1999. Absolute community of property. Kaning property regime, the first one. Mo niyang default by the family code. How is it defined? The community property consists of all the property owned by the spouses at the time of the celebration of marriage, and those either one or both of them acquired during the marriage. There is a presumption provided in the family code that properties acquired during the marriage belong to the community, unless it is proved that it is one of those excluded therefrom. What is the governing law? Article 80 of the Family Code. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by the Philippine laws regardless of the place of celebration of marriage and their residence. By nationality rule under Article 15 of the Civil Code, the rule that the absolute community property is the default mode of property relations absent any marriage settlement applies to all Filipinos regardless of the place of marriage and their residence, except when the spouses are aliens. So, diri ituod mo sa Philippines namin nyo, but you're aliens, so you're not governed by the nationality rule, and therefore, the default property regime is not ACP. Okay. 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located. Okay, because kuan man so pa tawag ani lex loci servationis siguro. 3. With respect to extrinsic validity of contracts entered into in the Philippines but affecting property situated in the country whose laws require different formalities for its extrinsic validity under Article 80. What happens to ACP if marriage does not take place? Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, if stipulations that do not depend upon the celebration of marriage shall be valid. Waiver is not allowed. Generally, no waiver of rights, shares, and effects of the absolute community of property during the marriage can be made, except when, in cases of judicial separation of property. When the waiver takes place upon a judicial separation of property or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Article 89 of the Family Code. Provisions on co-ownership apply. The provisions on co-ownership shall apply to the absolute community of property between the spouses and all matters not provided for in this chapter. Take note, the creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Can we go to conjugal partnership of gains? Okay, gorota. Conjugal partnership of gains. This property regime was formerly the default regime under the Civil Code. In here, the spouses retain ownership of their separate property. However, the spouses also place in a common fund the proceeds, products, fruits, and income of their separate property and those acquired by either or both spouses through their efforts or by chance. The presumption applies that all properties acquired during the marriage belong to the conjugal partnership of gains. There are three distinct patrimonies in their system: the husband's capital property, the wife's paraphernal property, and the conjugal property. Okay. In the next episode, we'll be comparing the differences between ACP and CGP para madali ta because it's freaking lot. Bye-bye.